So you want to know the difference between an inventive step and an innovative step. By now you know there are two types of patents, each requiring an element of inventiveness. A standard patent requires an inventive step, and an innovation patent requires an innovative step. Let's look at inventive step. This section tells us an invention may become a standard patent if it involves an inventive step. The invention must be compared with public information available at the time the patent application was filed. This section tells us there will be an inventive step if the invention would not have been obvious to an experienced, knowledgeable, and skilled person in the relevant area of technology. This is considered at the time the application was filed. Now let's compare that with innovative step. This section says an invention may become an innovation patent if it involves an innovative step. Again, this is determined by comparing the invention with information available at the time the application was filed. This section states there will be an innovative step if the invention makes a substantial contribution to the way the invention works. This is assessed by an experienced, knowledgeable, and skilled person in the relevant area, comparing the invention to available information at the time of application. These tests share some common elements. Both tests require the use of a person skilled in the relevant art as a standard for evaluating the required degree of inventiveness. They both require this hypothetical person to be armed with background knowledge and experience that would be expected common knowledge for persons in the relevant area of technology. And finally, both require a consideration of relevant information that was publicly available at the time of the patent application. The key difference between the tests is what must be decided from the perspective of the hypothetical person. For an inventive step, the question is whether it was obvious for the inventor to do what they did in the particular circumstances. So the courts must decide whether the non-inventive hypothetical person would have done the same thing in those circumstances because it was obvious. In answering this question, keep in mind, simplicity will not prevent something from being inventive. In assessing obviousness, one should not use the benefit of hindsight, and even a tiny amount of inventiveness will prevent an invention from being obvious. The test for an innovative step requires a comparison between the current invention and public information, such as another patent, from the perspective of the hypothetical person. This is to identify any differences between them and determine whether the differences in the current invention make a substantial contribution to the way the invention works. If there is a substantial contribution, there is an innovative step. Note that this test is generally easier to satisfy than the test for inventive step. So a standard patent with an inventive step may involve a completely new invention, like a shower that remembers your preferred temperature, or maybe the process for creating a mixture of chemicals to kill some weeds without killing useful plants. An innovation patent with an innovative step may involve a meaningful modification to another invention, like a treadmill adjusted for babies, or a roadside post that has been adjusted to avoid being broken when cars smash into them. So to finish up, remember, the inventive step test is about asking whether a person within the industry would find the invention obvious. And the innovative step test is about a person in the industry asking whether a current invention makes a substantial contribution which improves an invention over previous models.